Again, it just tells the story of it's the evil and the ugliness of people's hearts these days is everywhere.
This is Franky Rose's Think Tank. Here's your host, Franky Rose.
Hey guys, welcome to the Think Tank. So, jury instructions are coming up. The courtroom's got the camera on, but they're looking at the logo. So we're going to do this. And then what I'm going to do is I'll end the stream after they get their instructions. And then I'm probably going to watch the Jennifer Dulos trial with you guys. Kind of take another look. We haven't looked at that for a while. And just kind of see where they're sitting and go by that. How's everybody doing this fine Monday morning? What do you think of Justin Moan? What the hell is that? Oh my word. Unreal. Unreal. Yeah, that's a messed up boy. I don't think he'll be able to go for the insanity plea because, oh, good morning, Dandy. Crazy dude. Oh my God, wasn't he something? Oh, so yeah, they're going to be dealing with that for the next while. I'll be, I guess, how would I put that? I'll be interested to see if he goes to trial, and if so, like what kind of excuse does he have past the fact that, you know, he lost a $10 million suit? Because the timing with that one, that's what it looks like to me. You know, July is when they're like, are you kidding me? And that's the same time the neighbors are saying that he kind of started to lose it a little bit. So back to this trial. What the hell? We'll get these jury instructions, and do you think we're going to have a fast verdict? Do you think it's going to take them very long? And which way do you think they're going to lean? Do you think she's going to get her guilties? Or do you think that there's going to be somebody in there that hangs it, maybe? Or are we looking at, oh, they're going in, guys. There we go, boom. So I don't think Jennifer Crumbley will be there for this. I don't think she has to be. How do you think she did on Friday? Little Miss Shannon. Sharon? I guess okay. I still get that mixed up. How do you think she did? I've heard a lot of people saying, you know, basically she wasn't really the best at, oh, look at that suit. Wasn't really the best at being a trial attorney, but that her closing argument kind of rocked. Look at that outfit. This won't take long, I don't think. Oh, they turned their volume off. Not ready yet. It's kind of interesting because she's Shannon, right? Is loud. I think this guy's a rookie that's running this camera here. Oh my God. So this was just, it was a high schooly closing in your opinion. Oh, gotcha. Okay. Gotcha. All right. I don't think she did that bad. I have taken, like, my opinions, I've taken a dislike to the blonde in the state. I've taken a dislike to her. Like the very first time when she was holding her head and her face, that when this Shannon was screwing up so bad, I thought her reactions were kind of high schooly too, and it just totally turned me off of her. She did that kind of behavior right in front of the jury while that woman was imploding. And I just didn't think it was proper. And I just kind of thought she was a mean girl. And I have problems with mean girls. So, you know, I'm a little bit different than a lot of people in the chat who really, really like her. So, yeah, it's interesting. I mean, we all have our perspectives, right? But to me, she just rubbed me wrong like a mean girl in high school. I didn't like it, and it turned me right off. That's what I think. They've both been petty. So I'm not saying that I like the defense lawyer because I'm not a fan. To be honest with you, I'm not a fan. But I don't like the other woman either. So it's like, oh my God. I know that the courtrooms are dramatic and they're all good actors. And that part disturbs me, to be honest with you. I just wish that it would be straightforward. Everybody tell the straight line, the straight truth, and let juries go from that. But they allow so much BS on both sides to come out that it's just like, oh my God. You see a lot of juries when they're finished, they go, well, if I had known that, it would have been something totally different. And I don't like that. So I'll be really curious how this goes, mainly because of what the repercussions could be as far as parents getting charged for their kids' actions, you know? So I'm really curious about this. I don't know which way it'll go. I really, really don't. So it's very interesting. I'm still looking. Mexi and I were talking, and she said that the Jennifer Dulos case was heating up. So I want to take a look at that. And if it's boring as ish and we're not really getting much, we will not do an afternoon stream. I'll do some updates. But I do have it set, I think, for 7:30. I might have to bump it up because I'm not seeing any links for it yet. We'll see what happens when it hits 7 o'clock. If they'll give us one for 7:30. Maybe while we're doing this. So yeah, I love hearing everybody's opinions. I think it's awesome. That's one thing. I like kind of just sitting back and watching what everybody has to say. I think it's just, I love the diversity. And from all over the world. Did you have a good weekend, Andy? Young man on his way to school soon? I decided very last minute to do this, so I didn't give anybody really the heads up. It's hard when it's first thing in the morning with no notification. What? So, yeah, I don't know if anybody knows. I'm still watching for the shelter bonus. Uh-oh. I heard noise. Oh, hey, that's really nice, Andy. That's awesome. Hey there, P9. Nice to see you. Good morning, good morning, good morning. I'm on my third coffee, which is a lot of coffee for me. I don't want that overpowering. There we go. Now. Yeah, absolutely. I'm leg up. I injured myself like it's got to be over 2 weeks ago now, and I can't use my right leg very well. So I've been talking to my mods. What do I do? What do I do? I can't walk. But Mexi had the same injury. So, hubby's like, you have to go to the hospital. And I'm like, no, I'm allergic to those. No. So I just think it gets feeling a little bit better and I start to overdo it. And then I'm right back to trouble again. So she said about 6 weeks. I'm running around like a herd of turtles. Okay. Nothing, honey, not there, yeah. Oh yeah, I'll be fine. Long way from my heart. Knowing that it's supposed to take that long makes me feel a lot better. What were we watching? I think it was over the weekend, and I was like, it was something I really thought you were going to be interested in. Might have been the Richard Allen case. Really interesting because you've got a complete different perspective than a lot of us. Are you able to use your bike yet, P9? Is your weather good enough? We just got a massive dump of snow again. It's like, okay, well, we're back to winter, I guess. -9, which isn't too bad. Okay. A couple puffs of my cigarette and I'll come down. Is it still cold there? Yeah. You guys must get like a damp cold. I'm imagining, kind of like Vancouver. Yeah, we had rain for like a day. This is literally supposed to be like the coldest time of the year. The weather has been like unreal as far as like warm. It's rain in February. Are you kidding me? So yeah, it's super slick roads. And those mountain roads, oh, looky. Those mountain roads, you got to be damn careful. Here we are. Oh crap, my TV's on here. How do you put my clicker on my phone? It is so handy. Turn that volume on. I'm not that techy. Let's go. Giddy up. No. It's 32 right now. Yeah, I'm not complaining either, Dandy. I'm okay with this. What's going on with Vince McMahon? Yeah. I need to put some kind of translator in where I know what you like. That's almost like French to me. I'm just really crappy at converting Celsius into Fahrenheit or vice versa. Yeah, Vince McMahon. Hmm. Alrighty then. Oh, that's funny. Hmm. Maybe I'm way off of this trial. Does it what start at like 8:30 or something? Justin Moan. Like, are you kidding me, buddy? Okay, well, like I said, I'm not really seeing anything set up for that, so might bump it up again. Would be wise, I think. All right, I bumped it up again, just a half hour because I don't know. Judge said 9. So is that 8 for us? Or is that 9 for us? Oh no, you know how good I am with this stuff. I can barely do Canadian time zones. You told me Eastern 2 hours, so I know it's 9:05 there now. So why aren't they showing up? Yeah, it's not showing up. It's all about kind of for Crumbley right now. Ooh, what's this big crash? Oh no, a rig crash. So are they talking, when they call it a rig, are they talking about like a big, like a Kenworth or something? It's not in there now. Here we go, guys.
Oh, come on, Bill. I know. I know. That's okay.
Oh, she did come in. Yeah, you're 2 hours ahead of us because it's like 7 after 7 right now. Or yeah. Well, how odd is that it's not coming up? I had it in my, okay, it's 8 o'clock our time. I just found it finally. Okay, I got it for 8 my time. Oh, P9, I'm up by 4 just because I get up at 4 every morning, my little internal clock. And I get my coffee, my Mary Jane, my cigarettes, and I'm straight to my computer. Yeah, exactly. You got to get up to get your young man ready for school anyway. So yeah. And do you know what? Like, I think all those years of raising kids, you just start to, as you get older, your body already knows whether it's getting up for work or you just know. Are you an early riser too? Yeah. Yeah. I gave up my nighttime fun and traded in for peace and quiet in the morning. Something must have been walking around our house because my dogs were going batshit crazy for a while, like both of them. And usually Jazzy's my little barker, but both of them running like from window to window to window, to door. And I'm like, oh my God, what's out there? It's not unusual. I just don't think it's the right time, but it's not unusual to have bears like kind of walking around, nor is it unusual to have a cougar come in. So, oh my God, P9. Yeah, no. Yeah, Sasquatch too. Yeah, Sasquatch too, Dandy, you bet. So where you are, is it similar to us? Go here, Sasquatch pooped here, go over there, Sasquatch was sighted, go over here, there's a footprint. Do you have that all the way through your area as well? Oh, you got sleep issues. I'm sorry. That's hard. That's hard. Um, with my fibromyalgia, until I started getting the cortisone shots, I never slept. It was just impossible. Every move I made. Yeah, all kinds of stuff. Oh, is that right? So you're on the outside of the city? Is that right? I just have you just due to your name plopped in the middle of New York City. So Pikes Peak. Okay. Oh, I bet you do. Yeah, I've got PTSD from life. So my doctor ended up giving me something just to stop my bad dreams. Oh, okay. Gotcha. I bet you've got PTSD from working out of prison. Okay. Oh, here they come. Yeah, I got the PTSD from what do they call it? Multiple incidents or something along those lines. I don't know. I got my triggers. Okay, I'm gonna mute out.
Your Honor, calling People versus Jennifer Crumbley, case number 222799990 FH.
Good morning, Your Honor. Karen McDonald on behalf of the people.
Thank you, Marquise, on behalf of the people.
Good morning, I'm Shannon Smith on behalf of Jennifer Crumbley, who sits to my left.
Good morning. I think a couple things. I sent you an email over the weekend.
Thank you.
Regardless of the verdict in this case, we agreed that the gag order would stay in place until after the trials of James Crumbley. Is that
Yes.
correct?
That's correct.
All right. Can you approach anyone?
Silence. Yeah, they muted it for now. I can't imagine them muting like the whole jury instruction, though, can you? I am just updating something here. Okay. Oh, oh. Okay. Good morning, Shauna. The sidebar in, okay. Oh, look at that. Look at that.
Yes, sir.
The prosecutor's dressed like a leprechaun. She's the one wearing green.
You both have copies of the jury instructions.
Yes, sir.
Okay, so I'm going to sign copies of them as well.
Yes, thank you.
It's not a place I'd ever want to be.
I told them to bring all of their personal belongings, that's why it's taking a little bit of time.
I'm surprised they're able to message and text and do whatever. She's taking pictures of herself?
All rise for the jury.
Hey, sounds good, friend.
Good morning, you can see that. You've all been so wonderful and timely that, I have another jury starting next Monday, and I'm wondering if you'll all be willing to come back next week. No. Hard no? I'm gonna read you some jury instructions. You're gonna get a free copy of these in the jury room. Then I'm going to, pick 5 of you by random who are gonna be alternates. I know that you've all been in 2 different jury rooms, so, when you're brought together, it's gonna be like the show Survivor when the teams are merged, right? The tribes are merged, right? So, I know you've been in 2 different jury rooms, but, we'll be putting keeping the 5 alternates still sequestered in Judge Anderson's jury room, and the 12 will be in my jury room. That's why I asked you to bring your, personal belongings when you came here, right? Members of the jury, evidence and arguments in this case are finished, and I'll now instruct you on the law. That is, I'll explain the law that applies to this case. Remember that you have taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy, bias, or prejudice influence your decision. You must avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of the other jurors who may have different backgrounds and perspectives from yours. As jurors, you must decide what the facts of this case are. This is your job and nobody else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It's my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I've already given you some instructions about the law. You must take all of my instructions together as the law you are to follow. You should not pay attention to some instructions and ignore others. To sum up, it's your job to decide what the facts of the case are, to apply the law as I give it to you, and in that way to decide the case. A person accused of a crime is presumed to be innocent. This means you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty, unless you're satisfied beyond a reasonable doubt that she is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of crime beyond a reasonable doubt. The defendant is not required to prove her innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that's reasonable after a careful and considered examination of the facts and circumstances of this case. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it's important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of the witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I'll now describe some of the things that are not evidence. The fact that the defendant is charged with a crime and is on trial is not evidence. Likewise, the fact that she is charged with more than one crime is not evidence. The lawyer's statements and arguments and any commentary are not evidence. They're only meant to help you understand the evidence and each side's legal theories. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses, my questions to the witnesses are also not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, rulings, questions, and instructions are also not evidence. It's my duty to see that the trial is conducted according to the law and tell you the law that applies to this case. However, when I make a comment or give an instruction, I'm not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial of excluded evidence that was offered or stricken testimony that was heard, do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all of the evidence, regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during this trial. As I said before, it's your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You're free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a person's testimony, you must set aside any bias or prejudice you may have based on a witness's disability, race, national origin or ethnicity, gender or gender identity or sexual orientation, or religion, age, or socioeconomic status. Again, take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. There's no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth, or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how the case is decided? Have there been any promises, threats, suggestions, or other influences that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does a witness's testimony seem when you think about all of the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or is simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It's also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide this case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. James Robert Crumbley and Jennifer Lynn Crumbley are both on trial in separate cases. The fact that they are both charged is not evidence that either one is guilty. You should only consider the evidence presented in this case. Each defendant is entitled to have his or her case decided on the evidence and the law that applies to him or her. The prosecutor must prove beyond a reasonable doubt that the crimes occurred on or about November 30th, 2021 within Oakland County. The prosecution has introduced evidence of a statement that it claims the defendant made. Before you may consider such an out-of-court statement against the defendant, you must first find if the defendant actually made the statement as given to you. If you find the defendant did make the statement, you may give the statement whatever weight you think it deserves. In deciding this, you should think about how and when the statement was made, and about all the other evidence in the case. You may consider the statement in deciding the facts of the case and in deciding if you believe the defendant's testimony in court. Facts can be proved by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that's direct evidence that it's raining. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So, for example, if you see a person coming from outside wearing a raincoat covered with small drops of water, that would be circumstantial evidence that it's raining. You may consider circumstantial evidence. Circumstantial evidence by itself or a combination of circumstantial evidence and direct evidence can be used to prove the elements of a crime. In other words, you should consider all the evidence that you believe. There has been some evidence the defendant ran away and tried to hide after she was accused of the crimes. This evidence does not prove guilt. A person may run or hide for innocent reasons, such as panic, mistake, or fear. However, a person may also run or hide because of a consciousness of guilt. You must decide whether the evidence is true, and if true, whether it shows that the defendant had a guilty state of mind. You have heard evidence that before the trial, a witness or witnesses made a statement that may be inconsistent with his or her testimony here in court. You may consider an inconsistent statement made before the trial only to help you decide how believable the witness or witness's testimony was when testifying here in court. If the earlier statement was made under oath, then you may also consider the earlier statement as evidence of the truth of whatever the witness and or witnesses said in the earlier statement when determining the facts of this case. When the lawyers agree on a statement of facts, these are called stipulated facts. You may regard such stipulated facts as true, but you're not required to do so. You should not decide this case based on which side presented more witnesses. Instead, you should think about what each witness, about each witness and each piece of evidence and whether you believe them. Then you should decide the case. Then you must decide whether the testimony and evidence you believe proves beyond a reasonable doubt that the defendant is guilty. You've heard that a lawyer or lawyer's representative talked to one of the witnesses. There's nothing wrong with that. The lawyer or lawyer's representative may talk to a witness to find out what the witness knows about the case and what that witness's testimony will be. You've heard testimony from witness Detective Edward Wagrowski, who has given you his opinion as an expert in the field of forensic cell phone analysis. Experts are allowed to give opinions in court about matters they are experts on. However, you do not have to believe an expert's opinion. Instead, you should decide whether you believe it and how important you think it is. When you decide whether you believe an expert's opinion, think carefully about the reasons and facts they give for their opinion and whether those facts are true. You should also think about the expert's qualifications and whether their opinion makes sense when you think about the other evidence in the case. You've heard testimony from witnesses who are police officers. That testimony is to be judged by the same standards used to evaluate the testimony of any other witness. In count one, the defendant is charged with the crime of involuntary manslaughter. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Madison Baldwin. That is, that Madison Baldwin died as a result of storing a firearm and its ammunition so as to allow access to the firearm and ammunition by her minor child. Second, in doing that act caused Madison Baldwin's death, the defendant acted in a grossly negligent manner. In count two, the defendant is charged with the crime of involuntary manslaughter. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, the defendant caused the death of Tate Meir. That is, that Tate Meir died as a result of storing a firearm and its ammunition so as to allow access to the firearm and ammunition by her minor child. Second, in doing the act that caused Tate Meir's death, the defendant acted in a grossly negligent manner. In count three, the defendant is charged with the crime of involuntary manslaughter. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, the defendant caused the death of Hannah St. Juliana. That is, that Hannah St. Juliana died as a result of storing a firearm and its ammunition so as to allow access to the firearm and ammunition by her minor child. Second, in doing the act that caused Hannah St. Juliana's death, the defendant acted in a grossly negligent manner. In count 4, the defendant is charged with the crime of involuntary manslaughter. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, the defendant caused the death of Justin Schilling. That is, Justin Schilling died as a result of storing a firearm and its ammunition so as to allow access to the firearm and ammunition by her minor child. Second, in doing the act that caused Justin Schilling's death, the defendant acted in a grossly negligent manner. As I explained earlier in my instructions, the prosecutor asserts 2 different theories to support the charges of involuntary manslaughter. First, the prosecutor claims that the defendant committed involuntary manslaughter because she failed to perform a legal duty. In the alternative, the prosecutor claims that the defendant committed involuntary manslaughter because she was grossly negligent. Those theories are 2 different ways to prove the same crime. Either or both of these theories, if proven, are sufficient to establish the crime of involuntary manslaughter. It's not necessary that you all agree on which theory has been proven, as long as you all agree that the prosecutor has proved at least one of those theories beyond a reasonable doubt. In count 1, the defendant is charged with the crime of involuntary manslaughter resulting from a failure to perform a legal duty. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant had a legal duty to Madison Baldwin. The legal duty charged here is one imposed by law. In Michigan, a parent has a legal duty to exercise reasonable care to control their minor child so as to prevent the minor child from intentionally harming others or prevent the minor child from conducting themselves in a way that creates an unreasonable risk of bodily harm to others. This duty arises when both of the following are true. A, the parent knows or has reason to know that they have the ability to control their minor child. And B, the parent knows of the necessity and opportunity for exercising such control. Second, that the defendant knew of the facts that gave rise to the duty. Third, that the defendant willfully neglected or refused to perform that duty, and her failure to perform it was grossly negligent to human life. Fourth, that the death of Madison Baldwin was directly caused by defendant's failure to perform this duty. That is, that Madison Baldwin died as a result of the defendant's failure to exercise reasonable care to control her minor child so as to prevent the minor child from intentionally harming others, or the minor child from so conducting himself so as to create an unreasonable risk of bodily harm to others when the defendant knew that she had the ability to control her minor child and knew of the necessity and opportunity to do so. In count 2, the defendant is charged with the crime of involuntary manslaughter resulting from a failure to perform a legal duty. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant had a legal duty to take mere. The legal duty charge here is one imposed by law. In Michigan, a parent has a legal duty to exercise reasonable care to control their minor child so as to prevent the minor child from intentionally harming others or prevent the minor child from conducting themselves in a way that creates an unreasonable risk of bodily harm to others. This duty arises when both of the following are true. A, the parent knows or has reason to know that they have the ability to control their minor child. And B, the parent knows of the necessity and opportunity for exercising such control. Second, that the defendant knew of the facts that gave rise to the duty. Third, that the defendant willfully neglected or refused to perform that duty, and her failure to perform it was grossly negligent to human life. Fourth, the death of Tate Muir was directly caused by defendant's failure to perform this duty. That is, that Tate Muir died as a result of defendant's failure to exercise reasonable care to control her minor child so as to prevent the minor child from intentionally harming others or the minor child from so conducting himself so as to create an unreasonable risk of bodily harm to others when the defendant knew that she had the ability to control her minor child and knew of the necessity and opportunity to do so. In count 3, the defendant is charged with the crime of involuntary manslaughter resulting from a failure to perform a legal duty. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant had a legal duty to Hannah St. Juliana. The legal duty charge here is one imposed by law. In Michigan, a parent has a legal duty to exercise reasonable care to control their minor child so as to prevent the minor child from intentionally harming others or prevent the minor child from conducting themselves in a way that creates an unreasonable risk of bodily harm to others. This duty arises when both of the following are true. A, the parent knows or has reason to know that they have the ability to control their minor child, and B, the parent knows of the necessity and opportunity for exercising such control. Second, that the defendant knew the facts that gave rise to the duty. Third, that the defendant willfully neglected or refused to perform that duty, and her failure to perform it was grossly negligent to human life. Fourth, that the death of Hannah St. Juliana was directly caused by defendant's failure to perform this duty. That is, that Hannah St. Juliana died as a result of defendant's failure to exercise reasonable care to control her minor child, so as to prevent the minor child from intentionally harming others, or the minor child from intentionally harming others, or the minor child from so conducting himself so as to create an unreasonable risk of bodily harm to others, when the defendant knew that she had the ability to control her minor child and knew of the necessity and opportunity to do so. In count 4, the defendant is charged with the crime of involuntary manslaughter resulting from a failure to perform a legal duty. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, the defendant had a legal duty to Justin Schilling. The legal duty charge here is one imposed by law. In Michigan, a parent has a legal duty to exercise reasonable care to control their minor child so as to prevent their minor child from intentionally harming others or prevent the minor child from conducting themselves in a way that creates an unreasonable risk of bodily harm to others. This duty arises when both of the following are true. A, the parent knows or has reason to know that they have the ability to control their minor child. And B, the parent knows of the necessity and opportunity for exercising such control. Second, that the defendant knew of the facts that gave rise to the duty. Third, that the defendant willfully neglected or refused to perform that duty, and her failure to perform it was grossly negligent to human life. Fourth, that the death of Justin Schilling was directly caused by defendant's failure to perform this duty. That is, that Justin Schilling died as a result of defendant's failure to exercise reasonable care to control her minor child, so as to prevent the minor child from intentionally harming others, or the minor child from so conducting himself so as to create an unreasonable risk of bodily harm to others, when the defendant knew that she had the ability to control her minor child and knew of the necessity and opportunity to do so. There may be more than one cause of death. It's not enough that the defendant's act made it possible for the death to occur. In order to find the deaths of Madison Baldwin, Tate Meir, Hannah St. Juliana, and Justin Schilling were caused by the defendant, you must find beyond a reasonable doubt that the deaths were the natural or necessary result of the defendant's act. You heard the evidence that the defendant's son shot Madison Baldwin, Tate Meir, Hannah St. Juliana, and Justin Schilling. As previously noted, there may be more than one cause of death, and the defendant's acts or inactions need not be the sole cause of harm. In order to find that the death of Madison Baldwin, Tate Meir, Hannah St. Juliana, and Justin Schilling was caused by the defendant, you must also find beyond a reasonable doubt that her son's act of shooting someone was reasonably foreseeable. Gross negligence means more than carelessness. It means willfully disregarding the results to others that might follow from an act or failure to act. In order to find that the defendant was grossly negligent, you must find each of the following three things beyond a reasonable doubt. First, that the defendant knew of the danger to another, that if she knew there was a situation that required her to take ordinary care to avoid injuring someone. Let me read that again. First, the defendant knew of the danger to another, that if she knew there was a situation that required her to take ordinary care to avoid injuring another. Second, that the defendant could have avoided injuring another by using ordinary care. Third, that the defendant failed to use ordinary care to prevent injuring another when, to a reasonable person, it must have been apparent that the result was likely to be serious injury. I think I've told you this before, I'm not sure we did the greatest job at this, but I previously ordered the parties to be precluded from using the shooter's name during the trial. When you go to the jury room, you'll be provided with written instructions of the final jury. You'll be provided with a written copy of the final jury instructions, and you should first choose a foreperson. The foreperson should see to it that your discussions are carried on in a business-like way, and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communications equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it's necessary that each of you agrees on that verdict. In the jury room, you will discuss the case amongst yourselves, but ultimately, each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. It's your duty as jurors to talk to each other and make every reasonable effort to reach agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. However, although you should try to reach agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own, and you must vote honestly and in good conscience. If you have any questions about this jury instructions before you begin deliberations or questions about the instructions that arise during deliberations, you may submit them in writing in a sealed envelope to my clerk. Possible penalties should not influence your decision. If the defendant is found guilty, it's my duty to fix the penalty within the limits provided by law. If you want to communicate with me while you're in the jury room, please have your foreperson write a note and give it to the clerk. It's not proper for you to talk directly to me, the lawyers, the court officers, or any other people involved in the case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with the unanimous verdict, do not reveal this to anyone outside the jury room. When you go to the jury room to deliberate, you may take your notes and full instructions. I believe that the defense exhibits are hard copy, and the prosecutor has their exhibits on a thumb drive. We have a computer that we're going to set up in the jury room, and you can look at those exhibits. If you want anything else, you can let us know. I think it's a thumb drive, right?
It's a portable USB or hard drive.
And Your Honor, I just want to make sure that mine are in a binder. I left it for Ashley.
Okay, okay. Yeah, we're gonna send all the exhibits in right away, all right? We'll give it a written copy. I think I told you this earlier. We can replay a witness. That's very possible. And I think I told you this in the beginning of the trial. You can't, however, fast forward to the spot where you have a question and I'll yell, aha. You have to hear the whole witness, direct, cross, redirect. It's the only way that's fair to both sides, but it is possible to replay testimony, all right? The defendant is charged with 4 counts of involuntary manslaughter. These are separate counts, and the prosecutor is charging that the defendant committed all of them. You must consider each count separately and all of the evidence in the case. You may find the defendant guilty of all or any one of these counts or not guilty. I have a verdict form here. It's like a flow chart. There's questions. Number 1, involuntary manslaughter as to Madison Baldwin. You can check not guilty or guilty of involuntary manslaughter as to Madison Baldwin. Count 2, involuntary manslaughter as to Tate Muir. Not guilty, guilty of involuntary manslaughter as to Tate Muir. Count 3, involuntary manslaughter as to Hannah St. Juliana. You can find the defendant not guilty or guilty of involuntary manslaughter as to Hannah St. Juliana. Count 4, involuntary manslaughter as to Justin Schilling. You may find the defendant not guilty or guilty of involuntary manslaughter as to Justin Schilling. So I'm amazed that we maintained 5 alternates. It's a credit to how great you were at being here in time and following the instructions, and we're so appreciative. So we're going to choose 5 alternates, but I'm still going to sequester you. All right. I'm gonna have you kind of cool pulling your heels and being bored in Judge Anderson's jury room. If deliberations went beyond today, I might consult the lawyers about dismissing some or all of you. I think you can imagine that this has been a very emotional and stressful event for both parties, the prosecutor, the defense, and the families, and it's been a lot for the courthouse too. So you all look really healthy, but life happens. So I am going to sequester 5 of you. When I pick your names, my clerk is going to take you to Judge Anderson's jury room. You've all ordered lunch, so we'll match up the numbers and you'll get your lunch in a while. I know you're gonna be kind of bored still for a while, but we just want to be sure that we can conclude this trial. Then the other 12 of you will go into my jury room and start deliberating. I should also say the 5 of you that are sequestered still cannot discuss the case or do research or Google it or look at newspapers or go on Facebook. So you're still sequestered as if you're home. All right. Sometimes I would, I thought about sending you home, but I'm gonna keep you for a little while. But you're still sequestered. Can't look at any media or talk to anyone about the case and can't discuss the case amongst you 5. The 12 of you can start deliberating momentarily. I'm going to consult with the lawyers to make sure that there aren't any errors in the jury instructions. Bring in the exhibits and then you can start deliberating. It's important that you only deliberate when you're all there. If one of you steps out for some reason, you should be deliberating. And you can send us notes about when you want to take a break. I still would like you not to go to the cafeteria, please. And be careful if you're walking through the courthouse, because there's obviously a lot of interest in the case, as you know. And we've gotten this far, so in any event, I'm going to choose 5 of you randomly, and those 5 of you will go to Judge Anderson's jury room. You're in seat 15. You're 15, seat 15. You're in seat 17. You're in seat 10. Are you 10? Seat 10? You're in seat 10. Sure. In seat 4. In seat 4. And in seat 9. All right. So 17, 15, 9, 10, and 4. I'm sorry they could tell you before. We'll get back to you as soon as possible. All right. I did bring some cookies, and there's candy, and there's muffins, and what else? Licorice, oranges, apples. So if you could, I'm trying to think of it. Might be best to come this way. There's. Can they go both ways? I know it's so crowded. It's the coziest my new box is ever. So I'm gonna ask the alternates who I chose to go to Judge Anderson's jury. We'll bring you coffee too. All right, so I'm going to ask you to go to the jury room. Give me a moment. I want to consult with the lawyers to make sure that there are no errors in the jury instructions. And then I'm going to send in all the exhibits and copies of the jury instructions for you. All right. And if you all decide you're going to leave and walk around or whatever you're going to do, just let us know. We will all be awaiting you. Okay. All right.
All rise for the jury.
No, it does not compete.
Nothing from the defense.
We're gonna send in, the jury instructions, and you're giving us,
Yeah, for sure.
yeah, that computer can, right? You're not giving us any hard copy.
Correct.
Right, yeah, okay, and we have your exhibits. Please make sure we have phone numbers for you, because, you know, we get that usual question, we have copies of the police report, all the questions are usually come out of there, so.
There are 5 exhibits that we didn't include in the USB to the jurors. That's the shooting video, photograph with the blood from the bathroom,
Okay,
crime scene photo depicting the 2 victims, the video that was played with Gibson Marshall, and the video that was played with Molly Darnell.
okay, do you want me to somehow tell them that?
I think
Maybe
they
read
should
that.
they should be made aware of that, Judge.
Oh, okay, well, I would have told them that before we went in. Can you write those things? Do you want me to just tell them?
That's fine. I can write a note on the envelope.
Okay. Or we can give you a, maybe write it there, no, just, if you can initial it, and you just initial it. Alright. What else? Please just be sure that we can find you, because sometimes there's questions.
I'm gonna be right here.
How many
We're close by.
sets of instructions are you sending? We could send 12 sets of instructions. Is that it? Maybe I'll throw.
Massive grater outside my house right now. So what I'm thinking
Yeah, and then I gave the binder, so.
is I will keep this up, but I'm gonna get ready for the other stream here in a minute or two. Gonna do the morning of Michelle Triconis and see if we're interested. And there's also tomorrow the opening statement, or not, sorry, they're doing the jury, picking a jury
Hope everybody here
for
have any interaction with any of the jurors.
Adam Montgomery's case. That's another horrifying one. So yeah, I'm gonna try and squeeze that all in. So I'll keep my eye on this and see if the jury comes up with anything. And if it does, I'll probably stop streaming the other case, just pause it, give the update, and then back to what I'm doing. So I might, yeah, we'll just see how the morning goes with the other case, see if it's interesting to anybody, and go from there. So guys, I will talk to you later. Thank you very much for being here with me. I appreciate you. Don't forget to subscribe, like, and share, and I'll see you in the next one. Bye.